Welcome. You're listening to another episode of AML Conversations, where we sit down with some of the brightest minds in the financial industry to explore topical matters around financial crime and compliance. We hope you enjoy this discussion, and please be sure to subscribe for more.
Stef, how are you doing today, man? Appreciate it.
All right. I didn't know what I was supposed to do when I saw the invitation. It showed up 3 times, and I hit various different things, and whatever I hit last made this happen. So,
well, yeah, we'll just chalk that up to technology can be really useful, and other times it can be confusing. So I appreciate your
yeah.
doing that. So we did an interview a few years ago, pre-COVID, where we were able to sit in person, and you were kind enough, as you did this year, speak to my class at George Mason on the very both complicated and in some ways simple areas of asset forfeiture. And as folks know in the AML community, you are the CEO of Asset Forfeiture Law, LLC, a long career in government. Now you're in the private sector helping government and helping others as well. You've also written at least, I think at this point, 2 treatises, right, on
Yes.
federal money laundering crimes and forfeiture and the asset forfeiture law in the U.S.
Right.
I've always felt that the use of the asset forfeiture tool, if you will, doesn't get as much credit as it should. It's obviously you're going after illicit funds or properties or what have you. So I thought it'd be useful, before we talk about some specifics, if you could give us a quick primer on asset forfeiture, both how it's used in the civil context and how it's used in the criminal context. And I'll ask you some follow-ups after that.
Sure. Well, asset forfeiture is become a critical and essential law enforcement tool. It's used for all kinds of purposes: to punish the bad guy, to make sure the property that he used to commit the crime isn't available to be used again, to deter other people from committing the same crime. If the last guy didn't get to keep the toys, maybe the next guy will not be so inclined to commit the crime. Getting money back to victims, making sure there's a level playing field so that people who profit from illegal activity don't compete unfairly in the marketplace when they want to establish a business, open a restaurant, or whatever it might be. We don't want to be the repository for the world's criminal proceeds, and so we use forfeiture to stop kleptocrats from investing in the United States. Generally, it's done as part of a criminal case. Generally, forfeitures follow the prosecution. If the defendant's convicted of a crime, then the judge will impose forfeiture as part of his sentence. And in most cases, Congress has authorized the forfeiture of the proceeds of the crime. And in some cases, it's authorized the forfeiture of the property used to commit the crime, the facilitating property. And either one or both can be forfeited if the defendant is convicted. And that's called criminal forfeiture. It's just part of the defendant's sentence. And as I say, it's fairly routine. What's different is civil forfeiture. And the government uses that when a criminal forfeiture is not possible or not advisable. When the defendant is dead, he's a fugitive, he's overseas and outside of our jurisdiction. When the property is identified as being the proceeds of crime, but it was in the hands of a courier, or for some other reason we don't know who committed the crime, and for lots of other reasons. Sometimes when in the interests of justice, it's just more appropriate to take the property than it is to bring a criminal prosecution. So those are the civil forfeiture cases, and as I say, they're the gap filler when it's not possible or appropriate to bring a criminal case. And both civil and criminal forfeiture are used every day in the federal system, and for all the purposes that I mentioned.
So when properties are forfeited, as you say, sometimes it makes it a level playing field. In other cases, the government gets, well, you tell me, gets some utilization of the property. Do they? I mean, so forfeited properties in some cases, does that become, again, owned by the federal or state government, or is that fairly unusual? Describe that. So I understand when it goes back to the victims, but when that's not either possible or part of the equation, how does the government utilize forfeited funds or forfeited properties?
Sure. Well, the first priority is to get the property back to the victim. So if the crime involved victims, if it was a fraud, if it was a theft, embezzlement, or whatever, and the government forfeits the property, the government takes title, but then it uses its ownership of the property to satisfy a restitution order that the court has imposed, or to otherwise reimburse the victims of the crime. So the government doesn't keep the money in a case involving victims. The very first case that I handled of any consequence many, many years ago, and John, I think you'll remember it, the BCCI case, we recovered $1.2 billion, and the government gave virtually all of that, aside from the amount of money that was required to pay for some computer access that cost some money off the top. You gave all the money back to the victims to be distributed in a pro rata way. So that's what typically happens. But if the case is like a drug case or another case where there are no identifiable victims, the money becomes the government's property. It goes into a law enforcement fund called the Assets Forfeiture Fund, and then is appropriated out of that to the various agencies that have a request for money for training, for equipment, and so forth. And there's also a separate program by which state and local law enforcement agencies that participated and assisted the federal government in a forfeiture case can get some of the property as well.
So two themes I want to cover. One is there's been criticism of forfeiture authorities, some suggesting that it lacks due process. I'm going to have you address that because I know you testified before the Civil Rights Commission earlier this year. So I want to hear about that, because that to me is very instructive, because you among any people know exactly how that can be sort of a, I won't say nuance, but obviously there's some things that don't get picked up by the media. This isn't bashing the media, but stories where, monies are taken from somebody on their way to the gardening convention or something, they tend to get the headlines versus maybe the reality. I want to go to that in a second. But the other thing that's very public now is the seizure of Russian assets from oligarchs, whether it's funds. Talk a bit about that, the use of asset forfeiture to take away the monies of oligarchs, because that's obviously a very valuable tool. Tell us your take on that, specifically since Russia invaded Ukraine.
Sure. Well, what's interesting, and alludes a little bit to your first point, but then I'm going to talk about your second. Everyone thinks it's a wonderful thing when the government can use the forfeiture laws to take away yachts and airplanes from Russian oligarchs, or more broadly, to take away the proceeds of a theft by a corrupt dictator in some country that he's stolen from his people and invested in the United States. Just as they think it's fine for the government to take money away from child pornographers and terrorists and human traffickers and all sorts of other people. But the cases, and the government does those cases day in and day out, and nobody criticizes them, nor do they get reported in the press. But what you see in the newspapers all the time is when some knucklehead gets stopped at a traffic light and he's got $60,000 wrapped in rubber bands in his car, and somehow that becomes a major issue for the media to report on, without understanding that that's only the beginning of the process. And this gets your, that point that we'll talk about in a little bit about due process. But in the cases of the Russian oligarchs, the seizure of the asset based on its connection to some crime is only the beginning of the process. It may take years to ultimately litigate all the issues that are going to be raised in these cases. But if the government can establish that a given person is using his property or has maintained his property in violation of the sanctions that have been imposed on him or on his company, or more generally on a class of people associated with Vladimir Putin's regime, and can establish that, it can get a seizure warrant. It has to go to a judge and get a warrant. Then it has to execute the warrant on the property, and if the property is overseas, that means it has to get a foreign court to assist. That's what happened in the case of the mega yacht Amadea, which was seized in Fiji in April. The Fiji government, the court, honored the warrant in June, turned the property over, and the yacht was sailed to San Diego, where it now is. So those are the first two steps: get a warrant and execute the warrant. But then that's just the beginning. Then the government has to establish the forfeitability of the property in court, and there's discovery, there's depositions, there's the objections by the property owner that, which is probably a shell company, that it's the owner, not the designated person who allegedly violated sanctions. And all of that can go on for years, maybe a decade, before the government finally takes title. And in the meantime, it has to maintain the property, which is a very great expense. So
Right.
it's not as if, announcing that we're going to seize Russian oligarchs' yachts and airplanes is going to result in the deposit of a tremendous amount of money in a bank account someday. And as good as a use of that would be to aid Ukraine for humanitarian purposes, it's not going to happen overnight.
I think that's important. And then on the other part, like I said, I saw we'll give folks information on your website, but I saw on your website you testified in South Carolina before their Civil Rights Commission to talk about, as you've already begun to discuss here, how civil forfeiture works, and address the specific criticism that they were looking at the time, that it lacks due process and is unfairly applied to minorities. Give us a little bit from both from your testimony and the follow-up questions that you had that the commission asked you that day.
Sure.
Talk a bit about that.
Okay. Well, there has, no program, no matter how effective or important to law enforcement, is going to long survive if people think that it's unfair. And that's why it's important for people to understand how civil forfeiture works. I mean, as I mentioned, the civil forfeiture cases are the cases that are brought when a criminal prosecution isn't feasible. But that doesn't mean that they're easy. The government, it doesn't require a criminal conviction, but the government still has to prove there was a crime. And it still has to prove that the property was connected to that crime, that it was the proceeds or that it was used to commit it. And the government has to prove that by a preponderance of the evidence. The property owner has a right to a jury trial. The government has to act expeditiously. There are strict deadlines. So many days after the seizure, the case has to begin, and so forth. Both sides have the right to discover each other's evidence in advance of the trial. The property owner has an innocent owner defense. Even if the government proves his property was used to commit a crime, he can still object that he didn't know it or that he tried to stop it. And all forfeitures are limited by the excessive fines clause of the Eighth Amendment, which says that a forfeiture has to be proportional to the gravity of the offense. So all of that due process is built into the system. The criticism comes from people who either don't realize that,
right,
or who stop at the end of the first sentence, which is who gets the money. And if at the end of the day, the police get to keep some of the money, that becomes a reason to object, no matter how much due process is involved. And that's unfortunate, because what it's become, it's part of the defund the police movement. If you want to defund the police, then you don't like the idea that the police get to share in the forfeited property. And I think that's, we have that sort of an unfortunate political cast has been placed on this. And that's why you see all the news stories are only about the seizures of small amounts of money during traffic stops, and never about the recovery of the bitcoins that were taken in a ransomware case, or the money that was stopped from going to a terrorist organization in the Middle East or whatever, which is what the Justice Department actually does day in and day out. When you mentioned the Civil Rights Commission, and one of the panelists asked me, well, isn't it true that most of the money seized in civil forfeiture cases in South Carolina is seized from Black men? And isn't that, in and of itself, isn't that a prima facie case that this is being applied in a discriminatory way? And I said, well, you have to tell me who are the drug dealers in South Carolina.
Yeah.
I don't know. I can tell you that when I first started in the Justice Department doing organized crime cases in Providence, Rhode Island, with the Patriarca family, that all of our defendants were Italian Americans. Diversity wasn't a big thing among the Patriarca family. When I was in Baltimore and we were focusing on all cash businesses that were not paying taxes, and we focused on liquor stores, it turned out we prosecuted a lot of Korean Americans because that's who owned the liquor stores. And when we shifted to cash businesses running gas stations and convenience stores, it turned out we had a lot of South Asians. So you got to tell me, who are the drug dealers in South Carolina? If it turns out to be one particular ethnic group, that
Right.
doesn't mean that they were being discriminated against. That's just who you encounter when you enforce the drug laws.
No, that obviously that makes sense, and statistics can be utilized, but you have to know context. So the context makes sense. Well, I want to focus a little bit on your international work because obviously one of the reasons that you're called upon to advise governments or other international organizations on asset forfeiture, because you've worked so much in the U.S. on U.S. federal law. I've known that because I've known you for several decades, and I know you worked on the money laundering legislation in the 80s and 90s, obviously the Patriot Act. So you have a lot of experience in crafting what policymakers want, but making it a rational. I don't mean it pejoratively, but making sure that the statutes are workable and all that. So when you get asked to advise outside, foreign governments, what typically are they looking for? Are they looking for you to help them create a statute out of whole cloth, to improve upon what they've used, or to get some third party with fresh eyes to make a determination? Hey, if you made some changes here or there could be a more efficient utilization, or is it a combination of all of that?
Well, it varies from jurisdiction to jurisdiction, and I have indeed been extremely fortunate in that I've been invited to go to a great many places around the world and to help them from the benefit of my experience with their forfeiture programs. In some cases, they already have an asset forfeiture statute on the books, but they don't know how to use it. It's brand new, or it's been underutilized, and they need training. I spent many years going back and forth to South Africa. I made a great deal of friends there and helped them establish their forfeiture program dating back to the early 2000s. And they would say now, and I agree with them, that they now have one of the most effective asset forfeiture programs on the African continent, not because of what I did. I just helped them get started, but they've really taken the ball and run with it. And they really have made great strides in using the tools that had been enacted. And other countries are in the same position. Most of the English common law countries have both civil and criminal forfeiture. They call the civil side non-conviction based forfeiture. Mm-hmm. But not all of them have had a great deal of experience with it. And sometimes I get invited over to train their judges, train their prosecutors, and so forth. In other cases, it's just so newly enacted, or it's in the process of being enacted, that they need help drafting the legislation. I was in Malta last year helping them draft the legislation, and then went back this year after it had been enacted to help train the judges and prosecutors. And I did the same in Latvia. And then there are countries that yet don't have non-conviction based forfeiture. That would be outside of the English common law countries. That's usually the case. And many countries are adopting it. And they realize that they need it for all the reasons I mentioned: fugitive defendants, unknown defendants, dead defendants, so forth. And I'm going to South America later this month to help at conferences explain how other countries use non-conviction based forfeiture and why they might want to implement it. And then if they ask, I might be available in the future to help them draft their legislation.
That's great, and that obviously leads me to your take on the U.S., since you've had a lot to do with the crafting and working again with policymakers and at the Justice Department through the past several decades? Do you feel that the criminal and civil forfeiture infrastructure that we have in the U.S. both is working well and doesn't really need any tweaking, or are there some things that if you had a chance you would maybe improve is the wrong word, but there's some additional things that you would advocate?
Well, sure. There's always some room for improvement. I think we have a very effective program. We forfeit billions of dollars every year, both in criminal cases and in non-conviction based cases, and return a tremendous amount of money to victims as a result. We have a real impact on crime and improvement of the effectiveness of law enforcement because of that. But every day I read a case or something and I say, there's a glitch in the statute. Congress enacted a statute creating a new crime and forgot to make forfeiture part of it.
Right.
Or they didn't, they only made the proceeds forfeitable and not the property used to facilitate. As an example, just in June, there was a lot of press given to the enactment of the first gun control legislation, the first effective gun control legislation in decades.
Right.
And it contained some new crimes. And Congress remembered to include some forfeiture provisions for those new crimes, but in some cases, only the forfeiture of the proceeds and not the property used to commit the crime. And that's unfortunate that they sort of missed that. Right. There's always something that you could fix here and there. And, it's just hard to get Congress's attention on those things to get them fixed when you need it.
Right. Well, I've been working with a group called the Antiquities Coalition for a number of years, looking at trying to get dealers and advisors in that space to be covered under the Bank Secrecy Act, and we were finally successful in doing that. It's not finished yet. There was an advance notice proposed rulemaking, and my understanding is there won't be an official rulemaking, official notice of comment until next January. But I also noticed in the past week, up in New York, there was Homeland Security and State Department and local, I believe the U.S. Attorney's Office, could have been the Manhattan DA, I apologize if I don't know exactly, that they were returning cultural artifacts to Cambodia, at least 30 what they considered to be stolen property, and some were like over 1,000 years old, which is pretty amazing. But I noticed that a couple of years ago, you've just posted it, but you wrote it several years ago for the North Carolina Journal of International Law, a debate, I guess, or at least a treatment of this issue that seems in the weeds, but not to me. I could certainly understand it. But the title of your article was Recovering Stolen Art and Antiquities Under the Forfeiture Laws. Who's entitled when there are conflicting claims? And I can just tell the limited amount of work I've done with the Antiquities Coalition, in some cases, auction houses and others will say, hey, we had no idea that what we were selling or purchasing was, stolen or what have you. And I'm interested in your take, and I would urge folks to read your article. But when you tackled that issue, what did you discover?
Well, number one, the recovery of antiquities and art is one of the most important uses of the civil forfeiture statute, because you almost never have the thief to prosecute. Right. The property is almost always found years or decades later and in the hands of a third party. The classic examples include not only the one you gave about archaeological resources and antiquities that are taken from other parts of the world, like the Cambodian statues, or things that are found in Southern Europe or in the Middle East and find their way here into the United States. But artwork that was stolen by the Nazis during the Holocaust or were stolen from museums in years afterwards, you don't have the person to prosecute. Even if you did, the statute of limitations will have run on the criminal prosecution. But you recover the property. And so you need civil forfeiture in order to do that. And the problem is, as I mentioned earlier, that in our appropriate zeal to ensure due process, we have created an innocent owner defense. Congress amended the statute more than 20 years ago to make it an affirmative defense in every case for the person found in possession of the property to say that he acquired it as a bona fide purchaser for value. And that's appropriate in many, many cases. Somebody steals money and then he uses it to buy a car. The car dealer maybe didn't know he was being paid with stolen money, and he gets to keep the money. The government should take the car from the thief when he bought it. So you want to protect the bona fide purchaser for value. But what if the bona fide purchaser for value is someone who claims, I bought this painting, and here you have the art collector or the heir of the Jewish family in Europe who says that's our painting. Who gets priority? And under the current law, if you use the forfeiture laws to recover the property, the bona fide purchaser prevails. And even though you have the victim sitting there saying, I never surrendered title to my property, it was stolen from me. And so that's something that has to be addressed to make sure that doesn't happen in cases where it shouldn't happen.
Yeah, I found that very interesting, and you have obviously recommendations in the article along the lines you just mentioned. Stef Cassella, again, Asset Forfeiture Law, LLC. You also have a monthly digest, the Money Laundering and Forfeiture Digest, that folks can subscribe to, that includes all sorts of coverage of cases, law changes, what have you, on civil, criminal, forfeiture statutes and money laundering statutes as well, international as well as U.S. based, and really appreciate you taking the time. And I'll get you out of here on this. Besides what you've already told us, you've told us a lot. What is it about asset forfeiture that people don't appreciate? I think you've already said there's due process and there's all sorts of things, so that's part of it. But is there anything else when you see coverage of the asset forfeiture tool, if you will, and I'm not blaming the media, but in the media or covered, what is it about asset forfeiture, besides everything you've already told us, that we don't understand or appreciate?
Well, just that it's not automatic, that there is a long process, that a seizure is the beginning and not the end, that a seizure of property is to forfeiture the way an arrest is to a conviction. You arrest a guy for an armed robbery, he doesn't spend the rest of his life in jail until he has a trial. And the same is true for forfeiture. All of these cases involve lengthy procedures. The only cases that happen quickly are the uncontested ones. And there are a lot of uncontested ones because when, somebody seizes a pile of cash and a kilo of cocaine and a bunch of loaded firearms from somebody, he doesn't always come forward and say, hey, that's my stuff, for understandable reasons. But aside from the uncontested cases, these are cases where they involve complex issues of law and a lot of exchanging of evidence over a period of time. And then at the end of the day, the idea is to reach a fair result, and I think they do.
Stef Cassella, thank you so much for sharing your insight today. Safe travels as always, and as I say to folks, for more information, go to his website, assetforfeiturelaw.us. Thanks a lot.
Thank you, John. Take care.
Thanks for listening to another episode of AML Conversations, brought to you by AML RightSource. To make sure you're staying up to date with what's going on in the industry, be sure to subscribe wherever you listen to your podcast to get the latest episode.